Right, and good day, you beautiful people. I was going to read the previous case because I didn't think this was out yet, but this is from the court report of yesterday regarding Yaxley Lennon and his sentencing. Now, I'm going to read the entire thing in one go because it's 20 pages. We should be able to do that. It might take a little bit of time, but bear with me and we'll go through this and see exactly what has been said and what has happened. So, as you can see, this is the proper court report. Before you use Mr. Justice Johnson, Solicitor General, and Yaxley Lennon, and Jamal Hiyazi. It's obviously just about the case. So, Aidan Esley KC and Adam Payson instructed by the Government Legal Department for the applicant. Sasha West KC instructed by Carson Case Solicitors for the defendant, Yaxley Lennon. Okay, so, right, paragraphs. Okay, 1. On July 22nd, 2021, following the trial of a libel claim, Nicklin J granted the claimant an injunction. The injunction prohibited the defendant from publishing certain specified allegations in relation to the claimant which Nicklin J had found to be defamatory and untrue. 2. The applicant contends that the defendant has, on 10 separate occasions, breached the injunction. She makes 2 contempt applications. The defendant admits breaching the injunction on the occasions and in the manner alleged by the applicant. The issue is the appropriate, if any, sanction. Right, facts. The order of Nicklin J. 3. The background is set out in 2 sworn statements of Deborah Chan Smith, the joint head of criminal casework, and a senior lawyer at the Attorney General's office. The accuracy of the content of those statements is supported by extensive exhibits to the statements. The defendant did not challenge the accuracy of Miss Chan's account of the background. So Yaxley Lennon didn't challenge. 4. In October 2018, the claimant, then 15, was involved in a short altercation with a slightly older pupil at his school. A recording of the altercation was published on the social media on or around 27th November 2018. The following day, the defendant published videos in which he spoke about the claimant, and he said that as part of a gang, participated in a violent assault on a young girl which had caused her significant injuries, and that he had threatened to stab another child. The defendant's videos were viewed almost 1 million times. As a result, the claimant became a target of... were viewed almost 1 million times. Let me rephrase that. As a result, the claimant became a target of abuse. He had to abandon his education and his family had to leave their home. 5. The claimant brought a claim for libel. The defendant defended the claim on the ground of truth. And what he had said was substantially true. Section 2 of the Defamation Act 2013. The trial took place over 4 days before Nicklin J judgment was given on 22nd of July 2021. Then you have the case reference. Nicklin J rejected the defence of truth and gave judgment for the claimant. Days before the handing down of judgment, the claimant placed a recording on social media in which he indicated his intention to publish the total evidence and proof, showing what the claimant was like and that the reality of what he had done, per Nicklin J at 165. In light of that evidence, Nicklin J heard submissions from the parties on July 22nd, 2021 as to whether an injunction should be granted and if so, on what terms. 6. After hearing submissions, Nicklin J granted an injunction the same day in the following terms. The defendant, Stephen, must not, whether by himself, his servants, agents or otherwise, howsoever, publish or cause or authorise or procure the publication of the following allegations or any similar allegations in relation to the claimant. That the claimant had, as part of a gang, in a violent assault on a young girl which caused her significant injuries. That the claimant had threatened to stab another child. That the claimant had bullied a child referred in the judgment as BWI. That the claimant had behaved in an aggressive, bullying manner towards girls and women. That the claimant had a propensity towards using or making threats of violence against other pupils at Almondbury Community School, and or that the claimant had attacked and injured a pupil at Almondbury Community School with a hockey stick. 7. The defendant was present in court when Nicklin J made the order. He was sent an unsealed copy of the order the same day, and he was served with a sealed copy of the order on the 23rd July 2021. The order contained a penal notice in red capitalised text on the first page of the order, telling the defendant that if he disobeyed the order, he might be held in contempt of court and imprisoned or fined or have his assets seized. The first contempt application. 8. On the 26th of June 2023, the claimant's solicitors wrote to the Attorney General and drew attention to what they said were breaches of the injunction by the defendant. They invited the Attorney General to consider investigating the matter in public interest. 9. On the 1st of November 2023, the applicant sent a letter before action to the defendant. The defendant's solicitor responded on the 8th of November 2023, stated that the allegations of the breach of the injunction were denied, and asked that all further correspondence be sent to the defendant electronically at a specified email address. That is an email address that the defendant was continuing to use in September 2024 to communicate with the court. The defendant's email address. 10. On the 7th of June 2023, the applicant made a contempt application, the first contempt application. By that application, the applicant contends that the defendant breached the injunction in the following respects. First bit. The defendant published or caused or authorised or procured the publication of a film entitled Silenced, which was made available online at URL given and thereafter widely republished online as intended for reasonably foreseeable by the defendant. For example, on YouTube, the film includes statements prohibited by the injunction. 2. The defendant made a statement in an online interview with Gareth Icke, made available on rumble.com on the 2nd of February 2023, in breach of the injunction. 3. The defendant made a statement in an online interview with Gavin McInnes, made available on Censored TV on 26th of May 2023, in breach of the injunction. We're starting to have a bit of a pattern here, aren't we, Stephen? 4. The defendant made a statement in an online interview with Emerald Robinson, made available in a podcast called The Absolute Truth on the 1st of June 2023, in breach of the injunction. The Absolute Truth, imagine that. A podcast called The Absolute Truth had the absolute lie on it. Imagine that. Irony. 11. The evidence in support of the application is set out in an affidavit of Miss Chan Smith dated 15th of May 2024 and the extensive exhibit to that affidavit. Directions hearing. 12. On the 14th of June 2024, Nicklin J made an order listing the first contempt application for a directions hearing. He ordered that the defendant attend the directions hearing. A notice in capitalised red text on the first page of the order states that the defendant must attend the hearing and that if he does not, a warrant for his arrest might be issued pursuant to CPR 81.7(2). The order also sets out the defendant's procedural rights in relation to the hearing, including the right to legal representation, and states that if he admits the contempt that he is likely to reduce the seriousness of any punishment by the court. Now we all know why he bent over backwards, crying to the judge that he was guilty. 13. The hearing was listed to take place at the Royal Courts of Justice on Monday 29th of July 2024. On Saturday 27th of July 2024, the defendant led a march from the Royal Courts to the Justice to the Trafalgar Square. A film, Silenced, was played. See paragraphs 57 and 62. The film showed that the defendant was aware of the injunction and the consequences of breaching it. During the film, the defendant repeated statements that the applicant says are prohibited by the terms of the injunction. On 28th of July 2024, the defendant sought to leave the United Kingdom. He was arrested for reasons that are unconnected to these proceedings, and he was interviewed. He was reminded that he was due to attend court the following morning. He was released. The defendant then left the jurisdiction. He did not attend the directions hearing on July 29th, 2024. Of course he didn't. He ran away. We all know that. At the hearing on 29th of July 2024, I decided to proceed in the defendant's absence. There's the case. In the light of a certificate of service and evidence to service of the proceedings of the defendant, I ordered that the defendant had been served with the first contempt application. I made directions for the determination of the application. 15. Adam Pater then, as now, with Aidan Earsley KC, represented the applicant. It appeared that Mr. Pater's submission and his account on instructions as to what happened on the 27th of July 2024 that the applicant might wish to bring a further contempt application. I considered that it was in the interest of justice and in the defendant's own interest for the reasons given in paragraph 38 below that any further contempt application should be dealt with at the same time as the first contempt application. I made directions accordingly. I also issued a warrant for the defendant's arrest to secure his attendance at the hearing. I directed that the defendant was permitted to apply to set aside the warrant within 7 days of the service order. I also directed that the warrant should not be executed prior to the 2nd of October 2024, both to give the defendant time to set aside the warrant without being at risk of arrest, and reduce the maximum period for which the defendant might be in custody before the hearing. The order was served on August 8, 2024. No application was made at that stage to set aside the warrant. The defendant apparently remained outside the jurisdiction. Second application to commit the defendant. Quite already on page 4. Might actually have to do this in 2 parts. Maybe even 3 or 4. 16. As had been heralded at the directions hearing, the applicant made a further contempt application on the 19th of August 2024, the second contempt application. By that application, the applicant contends that the defendant breached the injunction in the following respects, continuing the numbering from the first contempt application. Well, hang on, so 5. In an interview in which he held in Denmark, there's even more thing. This is why he's got 10 counts of it. Deary me. An interview held in Denmark on or about the 14th of June 2024, which was live streamed and a video was subsequently made available and remains available on YouTube. 6. In an online interview with Jordan Peterson made available on YouTube on 30th of June 24, which remains available there. 7. By playing his film Silenced in a version that included a new introduction at a rally in Trafalgar Square on July 27th in London. By sharing the film in its new version on his X Media account, which remains available. 9. By publishing or causing, authorising or procuring the publication of the said film in the version that included the new introduction on YouTube on 28th July 24. 10. An online interview with Brogan Garrett Smith on a podcast entitled Getting There, made available on YouTube on July 28th, 2024, and remains available there. Good God. That's incredulous. That really is incredulous, isn't it? Sorry, puppy. 17. The evidence in support of the second contempt application set out in an affidavit of Miss Chan, dated 19th of August 2024, and the extensive exhibit to that affidavit. The application set aside the warrant for the defendant's arrest. 18. No application was made to set aside the warrant for the defendant's arrest within the time required by the directions order. That is, by the 15th of August 2024. On the 21st September 2024, the defendant emailed the court from the defence email address and said that he would attend the hearing on the 28th to 29th of October voluntarily and asked if the warrant could be set aside. He was informed that he would need to make an application supported by evidence. No application was made at that stage. On 21st of October 2024, the defendant made an application to set aside the warrant for his arrest. The totality of the information provided in support of the application was this. I was never served with the proceedings and have been out of the country until 20th of October. I was not aware of the details of the warrant until recently, and I have not been able to instruct and are currently still in the process of instructing lawyers due to financial issues as I was debanked. Oh dear. I made directions for the determination of the application, including for the parties to make representations. On October 22nd, 2024, Carson Case solicitors were instructed to act on behalf of the defendant and filed a notice of acting. On 24th of October, the defendant filed a witness statement in support of his application to set aside the arrest warrant. He said that he was making the application to set aside the warrant only now because he had previously been confused about how to do so. He denied that he had been served with the proceedings. He said that he was due to attend a police station on 25th of October 2024. He was due to attend a police station on October 25th, 2024, to attend a rally on the 26th of October 2024, and attend the hearing on the 28th of October 2024. He gave his current address and said that he currently had no plans to leave the UK. Yes, because he's not a flight risk at all, is he? I refused the application to set aside the warrant for the reasons given in an order dated 25th of October. In summary, the defendant had breached an order to attend the previous hearing and instead left the jurisdiction. He had given no explanation for that, and I considered it remained necessary for the defendant to be arrested to secure his attendance at the hearing on October 28th, 2024. So, for a lot of people who are, claiming that he was on holiday with his kids, because a holiday with the kids really does supersede a court case, doesn't it? Some real gullible people out there. It's incredulous, it really is. Right, 23. Yeah, 23. On October 25th, 2024, the defendant issued an application notice 7 for the order that he had been served with the proceedings set aside. He provided evidence which he says shows that he was outside the jurisdiction at a time when the process server had said that he had personally served the defendant with the proceedings. So actually Lennon was lying, saying that he didn't get these papers, and the person who sent the papers actually gave them to him in person. Well done, Stephen. Well done for lying. Be that as it may, he gave no good explanation for the delay in making the application and set aside the order for July 30th, 2024. Further, he did not identify any purpose in the order that he sought, even if he were correct that proceedings had not been served on 13th of June 24. They did subsequently come to his attention. It is inevitable that if the order in relation to personal service of the defendant was set aside, a further order would be made to dispense with personal service. In the event, Sasha Was, KC, on behalf of the defendant, indicated that the application was not pursued. Shock. Tell you what, we'll go down to the end of... We'll finish at 27, so we'll leave it at 28, and then I'll do another video and keep on going to the end. Right. Sorry, 24. The appellant was arrested. Getting TikTok comments everywhere. The appellant was arrested in the execution of the warrant that I had issued on the 30th of July 2024. When he attended a police station on the 23rd of October 2024, he was accordingly brought to court on the 28th of October 2024. I'll tell you what, actually, we'll leave it there because that's the legal framework. Paragraph 25 is where we are at. We will continue this very shortly. Thank you very much for watching. So far, very interesting reading.